Hello, I'm Aaron Ellis. I'm the finance officer for TCO. We're here for the first of our Blue workshop series. It's called The Legal Side of Startups, led by Jacob Byrne. We're very fortunate that he's here to help us navigate through the legal framework of building startups. So Jake is an associate at Tidings and Rosenberg LLP and a Hopkins alumnus. He earned his BA at Hopkins in 2007 from political science, and he was also a lacrosse team member. Jake later went on to earn his law degree from UMD Francis King Carey School of Law in 2016, and he's very knowledgeable about the legal framework surrounding startups. And he's also, we're also very thankful to have him as the lawyer for TCO Labs. So without further ado, I'm honored to introduce Jake Byrne and our first workshop, The Legal Side of Startups.
Thanks, Aaron. Everyone, I know, hopefully everyone in front of me can hear. I think the mic's on. So as Aaron said, 2007 political science grad, and just a little bit about my kind of journey to law school, because it wasn't direct. Graduated, I ended up working in the medical device world, so I was a sales associate. And after gaining some traction there, I ended up starting to try to contract with some of the hospitals and the entities above the doctor level. And I would have a contract, take the contract in, and they would say, well, what does that contract mean? What does this mean? And I said, well, I have no idea. I need to call the attorney. So at that point, I said, all right, it's time to go to law school. And in preparing for this presentation, I said, Anthony, who's going to be here? He's like, well, it could be, it's open to anyone. So it could be people who just have an idea, people who have started a business. So I figured, hopefully now, just to take a quick poll, as most speakers do, of who's here who just has an idea, okay? And who's here who's already started a business, they're already operating, they're making money. All right, we got one. All right, perfect. And then the last question is, who here has an attorney in the family, knows an attorney, has talked to one, is an attorney? Okay, a couple. So I know who to avoid for the questions. Okay. So with that said, Tidings and Rosenberg, we are a mid-sized firm in Baltimore. We do a little bit of everything except for criminal law, I might say. But obviously, you know, most attorneys would say, I'm sure we have someone who can do that, and that would be my answer. For our topics today would be an introduction to the law, and it's good that most, if not all of us, haven't really made a decision yet or have much experience with the law. So I'd like to take a bit to say, okay, what's the law? And especially if you do decide to engage an attorney, understand kind of how the interaction works. Anthony can probably speak to this when he has a question. You know, most of the time it's, okay, well, tell me about it. So what's the business do? How are you organized? What are the documents? I need to see them. And also just kind of what the law is. And then for our purposes, a choice of entity, formation, and you'll see what Mr. Grossinger was talking about in terms of selecting your partner, the dissolution, because not everything really starts out with, everything always starts out with, okay, we're best friends and this is going to be great, and then it doesn't always work out that way. And then IP, and that's a broad topic, but what I decided to focus on is trademarks. Essentially, what happens is you guys have an idea, you guys have picked a name, a couple years down the road you want to expand. Well, it turns out somebody already uses that name, and now you have to pivot, but nobody in your market knows you as the other name, they only know you as this, and now you have something that you can't really sell. And I wouldn't be an attorney if I didn't make this the first slide. So please ingrain that into your memory. So what is the law? Okay, if somebody says the law, you think, all right, well, I can find it in a book. Well, I'll tell you right now, it's statutes, and if we're dealing with the statute, and if we're in court, a judge will say, well, what was the debate? Okay, so that even will find its way in there. Regulations, which is called administrative law. So a lot of times Congress passes a law, they delegate what the law is actually going to mean to an agency, and you have regulations at the federal, state. You also have municipal regulations, you have municipal laws, common law. That's when the judge interprets something and sometimes they make up their own little law, which they aren't supposed to do. But anyway, it's the precedent that lawyers rely on when they're writing their briefs. And advisory opinions, sometimes the Attorney General will put out, somebody will write in and say, we're not sure if what we're doing is okay. Why don't you talk to us? And the Attorney General will sometimes write an opinion and say, that we think if you do this, you'll be violating, or it's okay, so they provide guidance. Now, this was supposed to kind of come up in multiple parts, but what I've taken it, and I didn't learn this until my corporate tax class, my third year of law school, is that if you read a law, a regulation, there's really no answer, right? So where that line is in the middle, it's there somewhere, but you're not entirely sure where it is. So depending on what type of attorney you work with, and you would like to work with one on the green side of the line, is to say, here's where it is, okay, and there's a little bit of wiggle room potentially. Now, obviously if the law said this is illegal, right, so a speed limit, 35 miles an hour, well, we know to drive 35, right? So when you come down to it, they know when they're drafting these laws that if we draw the line, they'll inch up to it. So they want to keep people back a little bit, and it helps delay some of the progression there. Now, when we get into choices of entity, okay, we have sole proprietorship, partnership. There's 3 categories within partnerships. A joint venture, which I'll talk about now. So a lot of times you hear, joint venture thrown out. Well, it's essentially a partnership for a limited period of time for a limited purpose. So 2 companies come together. We want to buy this property, sell it, and then we're going to move on. You have a limited liability company, which is a creature of statute, so there's a Limited Liability Company Act, and then a corporation. So C, S, tax exempt. I didn't put nonprofit because there's plenty of nonprofits that make a ton of money. They make a lot of profit. And then B, call it a benefit corporation. I'm not going to speak to benefit corporations in detail, but a lot of companies start, and if you're a corporation, it's all about turning a profit, and it's all about the shareholders. It's maximizing profits. And you'll see in the next slide that if you do end up having some humanitarian ideals, well, the shareholders can say, you're not maximizing profits. I'm going to go ahead and file a lawsuit. You're not doing what's in the best interest of the shareholders and the companies. So I think it was around 2010, at least Maryland passed the benefit corporation statute, where now you can have a corporation and you can say, okay, 1% of our profits are going to go towards essentially nonprofit pursuits. I think the biggest example would be Patagonia right now. I haven't had much experience with that, but again, it just shows you that the choices are endless. So key questions: liability, right? You want to limit that. Tax, what type of business are you in? How flexible do you need to be? And I guess subconsciously I decided that tax was really important, which it is, so it's on there twice, but it actually works out, right? I thought about it this morning. Anthony wouldn't let me change it. I asked him. He said no. But anyway, and then what do you need to do in terms of future expansion? Are you in an entity form where you want to take the next step, but it's somehow limiting you? So partners, back up. I didn't want to talk about sole proprietors too much, but as an entrepreneur, if you're out there operating a business, well, and you haven't formed a company and it's just you, well, it's a sole proprietorship. At that point, if you enter into a contract, if you are driving your car in pursuit of your business, or for anything, every asset that you own, every penny that you've put into this is at risk, which is why people say form a limited liability company in order to limit your liability. Now, when we get into partnership, that's the definition, right? So there's a Uniform Partnership Act, and it's an association of two or more persons to carry on as co-owners a business for profit. So the three of you in your dorm suite have decided we're going to do something together. We're going to make a profit. Well, congratulations, you're in a partnership. And if I get one point across to you today, it's that one partner, if he goes out and he enters into a contract, well, now the partnership is bound and you are bound even though you didn't know about it. So now it's called, and that happens through the law of agency, which is a whole nother topic, but it is pervasive throughout business, is that if I have an employee, he is my agent, I'm asking him to do things on my behalf, he goes out and enters into a contract, gets in a car accident, well, I didn't tell him to drive like that, or I didn't tell him to enter into that contract, but he still held himself out, and now everybody is on the hook. So partnerships, in each partner, it's called joint and several liability. Now, you can limit your liability by having a limited partnership, which means that you have a general partner who is still liable, but now the limited partners are not liable. So if you have a partnership, the most effective way to do that is to have the general partner be a limited liability company. So that way they do have limited liability and the limited partners are no longer liable for the debts of the partnership. Taxation. Income and losses are distributed and or deemed to be distributed. So this is important. So if you're in a partnership and let's say it makes two partners in a partnership and it makes $100,000. Let's say for the benefit of the partnership, they decide, okay, well, we only have $20,000 to distribute to you. Well, because it all passes through to you, and let's say if you're 50% owners, each of you have been deemed to have been distributed $50,000. So now you have to pay tax on $50,000 worth of income with only $10,000 that have actually been distributed to you. So that's one thing that I think it impacts more lawyers than anything else, where it's great, now I have a 10% stake in some law firm that does a bunch of money and I have a tax bill that I can't pay. So that's another thing to think about. It's one level of tax. The partnership doesn't actually pay any income tax. It files an informational return, and all of that flows through to you. Limited liability company. So it's essentially a partnership, but they decided, okay, well, we need to limit liability. So now you can form an LLC. In order to do that, you have to file articles of organization, which are public documents. So you file that in Maryland, the SDAT, the State Department of Assessments and Taxation. And then you don't have to, but it's best if you draft a written operating agreement, which will define how the members of the LLC will share income, losses, and also can, at that point is when you start talking about, okay, well, what happens if we need to dissolve? Who's going to take care of that? One aspect of an LLC also in the operating agreement is whether you want to have a manager managed, member managed. Again, it's topics for another day, considering we're trying to think about it at high level here. And then taxation, it's also, again, the same as partnerships, one level of tax, though LLCs can elect to be taxed as an S corporation, or as a C corporation or an S corporation. So corporations. So now we're getting into something a little bit more official, a little bit more bulky. So instead of articles of organization, you're filing articles of incorporation. Again, that's filed with the state. How instead of an operating agreement, you're going to draft bylaws, which details how the governance is going to take place, who gets to vote on what and how, who gets to appoint who. You have a shareholders agreement, which is often called maybe a buy-sell agreement, where the shareholders are now talking about how they're going to operate. And you also have to keep a stock ledger, stock certificates. And these are all documents that, for example, we had a client asked a question about a trademark. And I said, well, why don't you bring in your articles of incorporation and all your organizational documents just so I can look at them. And he brought them out, and it was a company formed in 1970. And he pulled them out, and they were, yellow. They had never been looked at all. He said, what do I need to do with this? And I said, well, I just want to take a look at them, but considering the state they're in, it means you've had a pretty good business where nothing has gone wrong, right? Because the only time you need to really take a look at these is when there's a question, right? So one of the issues that we always deal with is let me look at that, because company comes to us and says, I want to do something. Well, okay, well, do your bylaws allow that? Do your articles of incorporation allow that? I want to issue more stock. Well, how many are authorized in your articles of incorporation? So these are all sorts of questions that, in year one, okay, here's going to be I have this number of stock, and now we're going to take on a new investor. Okay, well, am I authorized to do that? And the major difference is taxation. So you have two levels of tax. So the first dollar gets taxed at the corporate level, and then the second dollar, or the first dollar, is then taxed again when it is distributed to the shareholders. So going back to my talk about corporations and benefit corporations, here's a quote from a famous case that we discussed in law school. It's Henry Ford, and there's another portion of the case where he talks about, I just can't sell these things enough. I wish I could give them away. And the shareholder said, well, hang on a second. You have this money. You need to give it to us. So this actually got him, I believe this was in a deposition or on the stand, and this got him in a little bit of heat. But it really is all about the next dollar for corporations. So going back to the bylaws and just the overall, the general run of it is that shareholders own the corporation. They elect the board elects officers who then manage and run the company. So when we talk about corporations, well, who owns the company? Well, it's the shareholders, so major company, right? You have thousands of shareholders. Technically, they all own a little piece of that company. And in the entrepreneurial landscape, when you have trying to choose what type of entity we want to go with, well, if I'm an investor and I have the ability to give you money and I get a membership interest, so if you're an LLC, well, I don't want a membership interest because, again, remember that income and loss will be attributed to me. So essentially, investors will want to invest in a C corporation, so that way they can be a little bit more passive and not be taxed on that income. So intellectual property, I know, I believe Anthony mentioned that sitting down here, I sat in a couple of the talks, and there were some people writing code in front of me, so obviously this is a pretty important topic. For me, I'm more familiar with trademarks, but at this level, I think that trademarking your idea and just being able to market your company successfully, not have to worry about changing, is important. So we have three major categories: patents. Now, if you do have a patent question that requires you to go to someone with a bit more training than me, so in order to practice before the patent bar, you have to actually take and pass the patent bar, which requires some sort of engineering degree, some sort of science degree. So I wish I wasn't a political scientist, but some sort of biomechanical engineer. Copyrights, original work, that protects original works of authorship, and trademarks. So when we talk about trademarks, you have, in the lingo, it's a trademark or a service mark. So they're the same thing. They're both trademarks. And I put nice classification next to it because that is the international group of classes where you can say that, my widget, let's say the trademark is widget, and it is covered under, I make dishwashers. Well, dishwashers fall under a specific class. So that way the USPTO is trying to herd everyone into a specific category, so you're not just out there trademarking random names. So one difference, I'm sure you've also heard of trade names as well. Well, a trade name is just another name for a business. It's a doing business as. So we get that question a lot where we get a telephone call and say, I have a trade trademark question, and then they really just want to file for a trade name. Now, there's different kinds of protection. So you have common law trademarks, and I'm going to use, is everybody familiar with the Redskins trademark issue that's been going on? Okay, so Washington Redskins football team, National Football League. They had obviously a trademark for the name Redskins. Well, that was deemed offensive. They were stripped of their federal trademark. So what happened is that whenever they were formed, over the number of years, they had built up in each specific state common law trademark rights, because people know the Redskins. If I'm in Nevada, I know that I associate Redskins and that symbol with the Washington Redskins in D.C. They also, at the same time, filed for a federal trademark through the United States Patent and Trademark Office, which essentially gave them a national trademark, even though they had common law rights in each state. So once that was stripped, the federal trademark was stripped, they still had common law trademark rights, they just didn't get to go and sue in a central location in D.C. So now Washington, if they really want to enforce their trademark rights in Nevada, they have to file a lawsuit in Nevada. If they want to protect their rights in Michigan, they have to file a lawsuit in Michigan, whereas, well, they had that federal trademark, they could just go down in D.C. and preclude anyone in the United States from using that mark. So you also have state trademarks. Generally, I haven't dealt with a client or really saw a need to register with the state of Maryland. Generally just file with the federal United States Patent and Trademark Office for protection. So coming down to it, it's choosing a mark. So it's choosing a name. It's obviously very important, right? And another key piece of information is that if you speak to someone from a marketing standpoint, they may say, you need something where people can understand what it is. They can read the name and say, I know what that is. It doesn't take a mental leap. But that doesn't give you the best trademark. So when we're talking about choosing our mark, we have that aspect, and we also have the likelihood of confusion. So you have to do a trademark search, figure out, is there anybody else out there who's using the mark? There is a 15 or so factor test, but it really comes down to, does it look alike, and do they protect the same classes of goods? As I point out at the bottom there, you can have, let's say, a widget trademark for, I'll stick with the dishwasher, but then you can still, someone else can then come back and trademark widget for basketballs, right? So they're different things. So you can still have that. So as long as there's no confusion as to the source, because company A is making dishwashers, company B is making something else, and then also it's whether, are you selling in different trade channels? Yep. Okay.
We came up with a name for
Mm-hmm.
you might not be able to call it that. About what it does. So at what point can you trademark and then be told you can't use that? Like it has an incurrence of benefit that might be beyond
So that may be an FDA question, because it sounds like they're saying that you have a name, and from when you're going through your FDA process that, well, your product may not provide that benefit. So that is what I think would be more of an FDA question in terms of naming, because if I have a product from just purely a trademark standpoint, and I name it with something, but the product doesn't do that, then at that point, who knows whether that could be trademarked, because it obviously depends on what's actually the goods you're providing. I don't know if that answers your question. Probably doesn't, but.
I'm just wondering, is there anything in there where they actually check your product that they
Absolutely, they do. So you can file two types of trademarks. One is called an already in use or an intent to use. So for an already in use trademark, you file your application, and along with it, you provide what's called a specimen, which is showing how you use the mark. So it's essentially an advertisement. So it's showing that you do use that mark in association with the goods and services that you're providing. So we're getting in now talking about strength. You can trademark a lot of different things, but you may not get much bang for your buck. So sometimes we have conversations with clients of, can we trademark this? Probably, but you don't need to. Or you've been operating so long at this point, there's little risk of somebody coming along and misappropriating your mark. But there really are, this is provided by the courts, where you have fanciful, so these are the classic examples of Kodak. No one would associate Kodak with cameras. Same thing with Apple for computers. Then you have suggestive, descriptive, and generic. So going back to that first piece about marketing is that when someone comes out and they say, this is what it does, this is what it is, well, you say, well, again, it's kind of describing what it is. You're not going to get a trademark. Even if you do, it's not going to be really worthwhile. So it's a fantastic to have an asset, but if you build up your company and it's under this name and someone comes by and says, well, I got to probably rebrand this thing because this name you used isn't very good. Now, there is an opportunity to have what's called secondary meaning, which requires that you have a weak mark, but now everyone in the community, all the consumers know that it comes from you. So now that takes time. That's not something at the startup phase. That's something that you've built this up over some time, and now people know and they associate it with you. So that's it for my spiel. Any questions, feel free to ask now, or my information's up, and I think Anthony's going to make the presentation available. But yep.
If you were to
Mm-hmm. Well, it depends. So it's not just where you're sued. So if you form an LLC in Delaware, you always have to be able to have a resident agent to accept service process. So if you form the contract in Maryland, well, that contract could have a choice of forum clause, venue. So that's something that can be negotiated. A lot of times, if it's a tort, it could depend on where that tort happened. So it's not as simple as saying, okay, well, I formed a company in X state. I can only be sued there, or I will always be sued there. But essentially, if you're choosing to do business there, that's where they're going to file suit. And he asked about a Delaware company. So there's a phenomenon where most companies are formed in Delaware, and the reason for that is essentially they have built up this really big chancery court where lawyers and people drafting contracts and deals know that, okay, well, if I go into court in Delaware, well, I know what I'm going to get because they have a very highly trained and expertise in business. And they also just have a very forward-thinking corporate law as well. But to go back and answer your question, it depends on what's happened and what the contract says. Yeah, shoot. Mm-hmm.
Is dividing equity seems a little bit more straightforward, but how do you determine that
Well, that all depends on, I mean, in business, there's always an idea guy and there's usually a money guy, right? So it could be, okay, well, I'm putting up 80% of the money, so I'm going to get 80% of the money out. So I could have an 80% membership interest, and the other party could have a 20% membership interest. And one aspect of that is, in the operating agreement, you can provide that voting and control is based upon the contribution, so that 80%, or you can say it's going to be based, this is how it's going to be based. We can have two different classes of members. But again, LLC is very flexible. It's really up to how you want to do it. And a lot of times with these client interactions, here's the deal, this is what we want to do, can we do this, and how does it look on paper? So if you're more advanced, there's an accountant involved, and the accountant can say, this is the formula, and we draft the formula in the contract. But again, generally with LLCs, it's very flexible, and it can be, get very complicated if you want it, or be very simple as well. Yep.
Other than this, what other
So I do general business law. I passed the bar in December, so I am building up my practice. So my role as an associate at the law firm, just as you'll find in any company when you're new, is they say, Jake, can you do this? And I say yes. So for me, right now, it's really drafting operating agreements. So I personally, so even with TCO Labs, there's other attorneys involved as well. So you'll find that if you do engage an attorney or a firm, it's really a team effort, because you can't have it's hard to be a generalist, just as some of our speakers earlier today said. So there'll be a lot of different hands in the deal. So when I talk about clients, it would be our firm, represents the clients. It wouldn't be just me, even though I am involved with TCO. All right. Well, thank you for having me. And if there are any questions, again, feel free to send me an email, and hopefully we can help you out. Thank you.